Officer Mark Harland, a seasoned patrol officer with a record of formal grievances, aggressively approached the stationary luxury sedan, striking the window and sneering at the African-American woman inside. "Exit the vehicle immediately, or I will forcibly remove you and ensure you spend the night incarcerated." He was unaware that the collected driver was federal judge Elena Harper, and his recorded threats would soon precipitate the end of his career and result in his own imprisonment. Before we proceed further, kindly share your geographical location from which you are viewing this narrative, and be certain to subscribe, as tomorrow's story is one you will not want to miss. Officer Mark Harland had been patrolling the tranquil, affluent streets of Ridgeview Heights for 14 years, sufficient time to cultivate a reputation few dared to openly contest. Internal Affairs had investigated him on 4 occasions within the preceding 6 years, each instance involving either black or Hispanic drivers who alleged excessive force or racial profiling. Every complaint was ultimately dismissed, attributed to malfunctioning body cameras, a lack of witnesses, or statements that portrayed the motorists as non-compliant. His colleagues understood the wisdom of not crossing him. To Harland, an African-American driver behind the wheel of a late-model Mercedes in this neighborhood at 9:30 on a Tuesday morning represented sufficient probable cause. The black Mercedes GLS was legally parked adjacent to a modest cluster of upscale establishments, including a boutique bakery, a florist, and a private legal practice. The engine was operational, with the air conditioning engaged to combat the late spring warmth. Within sat Judge Elena Harper, aged 48, one of the youngest African-American women to ever be appointed to the federal bench in her district. She had diligently earned her position through unwavering dedication, an undergraduate degree from Howard University, followed by Harvard Law, and a decade spent as a federal prosecutor, successfully prosecuting corrupt officials, culminating in her judicial nomination 5 years prior. This morning she had recently dropped off her teenage son at his private school, a mere 10 minutes away, and had pulled over to attend to an urgent call from her clerk regarding scheduling for a prominent civil rights case. She was reviewing notes on her mobile device, her coffee growing cool in the cup holder. Harland's patrol car slowly cruised past, then circled back. He disapproved of the tinted windows and the fact that the vehicle had been idling for over 5 minutes, which, in his estimation, signaled suspicious activity. He positioned his vehicle behind hers at an angle, effectively impeding any easy departure, and disembarked with a deliberate stride. Elena observed the patrol car in her rearview mirror and terminated the call. She lowered her window by half as Harland approached, his flashlight already in hand despite the bright morning sunlight. "Good morning, officer. Is everything all right?" "License, registration, and proof of insurance," Harland demanded, bypassing any form of greeting. Elena maintained slow, deliberate movements. "May I inquire as to the reason for this interaction?" "This is an affluent area. We have received reports of suspicious vehicles surveying the neighborhood. You have been stationary for some time. Turn off the engine and step out." "I am amenable to providing my documentation," Elena stated calmly, reaching for her purse, "but I am legally parked and engaged in a work-related call." Harland's gaze hardened. "I instructed you to turn it off and exit the vehicle now." She complied, shutting down the engine and stepping onto the sidewalk, clad in her expertly tailored gray suit and low heels. The dash camera she had installed, prompted by numerous similar anecdotes from acquaintances, was already recording, capturing a wide-angle view with exceptionally clear audio. Harland took her driver's license and registration, scanned them, and then proceeded to scrutinize her from head to toe. "Elena Harper," he pronounced, his voice laced with skepticism. "It states here you are a federal judge." "That is correct." "United States District Court." He emitted a brief derisive chuckle. "Right, and I'm the mayor. Nice try. Do you honestly expect me to believe a federal judge is simply idling in a parked car in Ridgeview Heights? I am a federal judge, officer. You are in possession of my official identification." Harland roughly returned the license. "Anyone can procure counterfeit credentials these days. Is there anything within the vehicle that I should be aware of? Contraband, stolen property?" "No, sir." "Mind if I search it?" "Yes, I do mind. I have not provided consent for a search, and you have not articulated reasonable suspicion." His face flushed crimson. "You do not instruct me on how to perform my duties. You are verging on obstruction." "I am asserting my rights, officer." Harland advanced, looming over her. "Continue speaking with such insolence, and I will find a reason to place you in handcuffs right here. I have dealt with numerous individuals posing as persons of importance. It does not work on me." Eleanor met his gaze, her voice unwavering. "Everything you are saying and doing is being recorded, officer. I strongly advise you to reconsider your approach." He glanced at the dash camera for the first time, observed the steady red indicator light, and hesitated for a mere fraction of a second before doubling down. "Return to your vehicle," he snapped, "and do not let me encounter this suspicious vehicle in this area again. Next time my disposition will not be as accommodating." Elena returned to her seat, closed the door, and initiated the engine. She watched in the mirror as Harland swaggered back to his patrol car, radioing in her license plate number as a precaution. Only after he had driven away did she permit herself a slow exhalation. Her hands remained steady, yet a simmering anger lay just beneath the surface, not solely for herself, but for every individual who lacked the capacity to push back in the manner she could. The dash camera had meticulously documented every word, every threat, every dismissive sneer. By that afternoon, the footage was en route to the department's Professional Standards Unit, the United States Attorney's Office, and the FBI's Civil Rights Division. What Officer Harland had yet to comprehend was that the woman he had just subjected to humiliation and threats was not feigning her identity. She was precisely who she claimed to be, and she now possessed irrefutable evidence of his abuse of power, a discovery that would dismantle everything he had meticulously constructed over 14 years on the force. The wheels of justice, though often slow, were in this instance already in motion. By the time Judge Eleanor Harper navigated her vehicle into her driveway that morning, her initial composure had solidified into unwavering resolve. She transferred the dash camera footage to her laptop, created 2 encrypted backups, and dispatched the file to herself via email, prefacing it with a succinct subject line. "Incident Ridgeview Heights, 9:47 a.m. Subsequently, she made a telephone call. Her initial contact was with the department's Professional Standards Bureau. Identifying herself and providing her badge number, she stated that federal judges carry official credentials and requested to formally lodge a complaint against Officer Mark Harland. The intake sergeant on the line fell silent for a beat upon hearing "federal judge." He then assured her that an investigator would contact her within the hour. The second call was placed to Assistant United States Attorney Marcus Reyes, a former colleague from her prosecutorial tenure. "Marcus," she began without preamble, "I have video evidence of a uniformed officer threatening to forcibly remove me from my vehicle and arrest me for the offense of being legally parked while black. I require guidance regarding the civil rights implications." Reyes did not waste time expressing surprise. He requested the file and informed her that the Civil Rights Division would be eager to review it. Within 48 hours, the footage had disseminated like wildfire through official channels. Internal Affairs commenced case number PSB 2025-417. The FBI field office flagged it for a potential violation of 18 U.S.C. paragraph 242 concerning the deprivation of rights under color of law. Furthermore, an unknown individual, whose identity Elena never ascertained, leaked a 30-second segment of the recording to a local news outlet. That evening, the story headlined the 6 p.m. broadcast, "Federal Judge Claims Racial Profiling by Local Officer, Exclusive Video." Officer Mark Harland was engaged in bench pressing at the precinct gym when his mobile device began to buzz incessantly. Colleagues who had previously chuckled at his exaggerated accounts now averted their gaze. His sergeant summoned him to the watch commander's office and presented him with a notice of suspension. "Administrative leave, pending investigation." His badge and firearm were confiscated on the spot. Harland stormed out to the parking lot, his face burning. "Suspended for telling some woman to move along. Are you serious?" He contacted his union representative, whose tone conveyed an unusual degree of caution. "Mark, the video footage is problematic. Severely problematic. And she's actually a judge. A federal judge." That night Harland sat in his dimly lit living room, a beer in hand, scrolling through social media. The clip was ubiquitous. Captions read, "Another day, another racist cop, and he picked the wrong one today." The comments section called for his badge, his pension, his freedom. He posted a private message within an officers-only group. Liberal media blowing it out of proportion. She was suspicious. I did my job. A few likes trickled in, then ceased. Even his usual supporters remained silent. 2 days later, investigators arrived at Elena's chambers. 2 individuals from Internal Affairs and 1 FBI agent. They viewed the complete 23-minute video in silence. Upon its conclusion, the lead IA detective, a white woman who had previously closed Harlan's cases, cleared her throat. "Judge Harper, we are treating this matter with the utmost seriousness." Elena nodded. "I expect nothing less." They interviewed Harlan the following morning. He sat across from them in a small room, his union lawyer at his side, repeating the same assertions. "I observed a suspicious vehicle in a high-crime area. Well, high for burglaries. The subject was uncooperative. I de-escalated and disengaged. When they played the video, his jaw tightened. He insisted her identification appeared questionable and that her demeanor was confrontational. The lawyer interjected, 'My client followed department policy.' However, the policy manual was unequivocal. No reasonable articulable suspicion, no basis for detention, no consent for a search, and clear evidence of excessively aggressive treatment. Prior complaints, once suppressed, were retrieved from the archives and added to his file. Public pressure intensified. Community activists organized a press conference outside the precinct. National civil rights organizations issued statements. The mayor's office called for swift and transparent action. Harlan's name trended regionally on social media. A week after the stop, Elena received a call directly from the chief of police. "Judge Harper, on behalf of the department, I wish to extend our deepest apologies. Officer Harlan has been terminated effective immediately." She listened without interruption. "We have also initiated a comprehensive review of use of force complaints over the past decade," he continued. "Your footage has, opened eyes." "Thank you, Chief," Elena replied. "However, termination is merely the initial step. The United States Attorney's Office is reviewing potential criminal charges." The chief offered no argument. Harlan learned of his dismissal via a text message while seated in a bar he frequented while in uniform. The bartender, who once comped his drinks, now avoided his gaze. He drove home in silence, the weight of 14 years collapsing around him. Federal prosecutors proceeded expeditiously. 10 days after the incident, a grand jury returned an indictment. 1 count of deprivation of rights under color of law, enhanced due to perceived race-based animus. A warrant was issued. When agents knocked on Harlan's door at dawn, he answered in sweatpants, his eyes bloodshot. They read him his rights, handcuffed him in front of his neighbors, who were filming, and escorted him to a waiting vehicle. As the cruiser pulled away, Harlan stared out the window, replaying that morning in Ridgeview Heights. He had been so convinced he was in control. He had no conception of how profoundly mistaken he was. The criminal trial was scheduled for the fall docket. Judge Eleanor Harper would not preside. She had recused herself, but she would testify. And the video, which everyone had now viewed countless times, would be presented again, this time before a jury. Justice for once was moving with alacrity. 6 months after the morning in Ridgeview Heights, the federal courthouse was abuzz with a level of attention rarely witnessed in routine criminal proceedings. Cameras lined the steps outside. Protesters on one side held signs proclaiming "Justice for Judge Harper" and "End qualified immunity," while a smaller countergroup displayed faded blue flags. Inside, security was tripled. The case of United States versus Mark Harlan had achieved national prominence. Harlan remained in pre-trial detention, his once robust frame thinned by jail rations and stress. Nights in the county facility blurred into one continuous cycle of clanging doors, fluorescent lights, and the incessant hum of men acutely aware of why he was confined. Former police officers did not fare well within the correctional system, even before conviction. His public defender again petitioned for bail, citing an exemplary service record, but the judge denied the request, citing excessive public outrage and numerous online threats directed at Elena Harper, deeming him a flight risk. Meanwhile, Elena continued to manage her caseload, though the incident cast a shadow over her daily activities. Anonymous letters arrived at her chambers, some supportive, many vicious. Her home address was leaked online. United States Marshals maintained a patrol car outside her residence for weeks. She granted only one televised interview, delivering a measured and composed statement. "This is not solely about me. It concerns every citizen who fears unequal treatment under the law." The clip went viral, shared millions of times. Discovery unearthed evidence that Internal Affairs had long suppressed. Prosecutors subpoenaed Harlan's old phone records, revealing text messages to fellow officers referring to certain neighborhoods as the zoo, private Facebook posts mocking Black Lives Matter protesters, and a meme joking about issuing driving while black tickets. 3 previous complainants, 2 African American men and 1 Latina woman, whose cases had been dismissed years earlier, now came forward, granted immunity to testify about remarkably similar encounters. The pattern was undeniable. Harlan's defense team, partially funded by a police advocacy group, filed a barrage of motions to suppress the dash cam footage, citing chain of custody issues, to move the trial, alleging prejudicial publicity, or to dismiss the case entirely, arguing a lack of intent to violate clearly established rights. Every motion was denied. The presiding judge, a white veteran appointed decades earlier, ruled the video admissible and the venue appropriate. "The public has a right to witness justice being served," he declared. Jury selection spanned 3 days. Prosecutors excluded potential jurors who expressed strong pro-law enforcement bias. The defense removed those who followed civil rights accounts online. The final panel comprised 6 women and 6 men, 5 African American, 4 white, and 3 Hispanic. Harlan's lawyer visibly grimaced. Opening statements set a decisive tone. Assistant United States Attorney Lauren Chen addressed the jury first. On a bright May morning, the defendant used his badge not to protect, but to intimidate a United States federal judge because of the color of her skin. You will see the video. You will hear him mock her identity, threaten her liberty, and refuse to retreat even when proven demonstrably wrong. This was not a judgment made in the heat of the moment. This was a deliberate deprivation of constitutional rights. Defense counsel then rose. Officer Harlan observed what any reasonable officer would deem a suspicious vehicle in a high-crime area. Judge Harper's demeanor escalated the encounter. He de-escalated and disengaged. No one was harmed. No rights were violated. This prosecution is nothing more than political theater. Then came the evidence. The dash cam video played in its entirety, 23 minutes on the expansive courtroom screen. Eleanor's composed voice, Harlan's escalating aggression, his mocking laughter upon her identification as a federal judge. The jury watched with impassive expressions, though one African-American juror's eyes glistened. When the screen went dark, the gallery remained silent for a prolonged moment. Elena took the witness stand next, wearing the same gray suit from that fateful morning, as if reclaiming it. Prosecutors guided her through the stop, detailing each minute. During cross-examination, the defense attempted to portray her as combative. "Did you raise your voice at any point?" the lawyer pressed. "No. You refused to consent to a search." "I asserted my Fourth Amendment rights." "Yes. Isn't it true that you advised him he should have considered his approach?" "That sounds confrontational." "It was advice," Eleanor responded evenly. "He was violating my rights in real time." The prior complainants followed, each recounting nearly identical encounters. Tinted windows cited as suspicious, identification mocked, threats of arrest. One man displayed a faded scar from where Harlan had allegedly slammed him against a car years earlier. The jury meticulously took notes. Then, against the strong counsel of his defense team, Harlan testified. He sat upright in his suit, his voice initially steady. "I treated her like any other suspicious vehicle. Race had absolutely nothing to do with it." However, under cross-examination, cracks began to appear. Chen played audio of him laughing at Elena's judicial identification. "So you believed a federal judge's credentials were fake?" "It appeared questionable. I've encountered fakes previously. You ran her plates. They came back clean. No warrants, no flags. Yet you continued the detention." "I was exercising caution." Chen then listed the unearthed text messages, Harlan shifted uncomfortably. Private jokes taken out of context. Context that included referring to citizens as animals. Objections were sustained, but the damage was done. Closing arguments sealed the fate of the case. Chen declared, he did not believe a black woman could be a federal judge. He did not care when proven wrong. He abused his authority because he believed no one would hold him accountable. Hold him accountable now. Defense counsel argued, reasonable officers make reasonable mistakes. Convict him and every police officer will second-guess every stop. That places all of us at risk. The jury received the case on a Thursday afternoon. Outside, reporters braved the rain. Social media erupted with predictions. Some declared a conviction certain, while others demanded the maximum sentence. Elena departed through a side exit, flanked by marshals, offering no comment. Harlan was returned to holding, staring at the floor as the door clanged shut. Deliberations extended into a second day, then a third. The nation awaited the verdict. What no one in that courtroom yet comprehended was the decisiveness with which the jury would speak and the far-reaching consequences that would ensue. The verdict was imminent. On Friday morning, precisely 7 months after the stop in Ridgeview Heights, the courtroom gallery was once again packed. Reporters occupied the back rows. Cameras were prohibited, but live blogs provided minute-by-minute updates. Judge Elena Harper sat in the front row, her hands folded, her expression unreadable. Mark Harland, clad in a dark suit that now hung loosely on his frame, stared straight ahead as the jury filed in. The foreman stood. On count 1, deprivation of rights under color of law, we find the defendant guilty. A murmur rippled through the room. On the sentencing enhancement for hate-motivated conduct, guilty. Harlan's shoulders slumped. His lawyer placed a hand on his arm, but he shook it off. Elena closed her eyes for a moment, exhaling slowly. Outside, cheers erupted from the crowd gathered on the courthouse steps. Sentencing was scheduled for 6 weeks later. Prosecutors submitted a lengthy memorandum requesting the statutory maximum of 10 years. They appended Elena's victim impact statement and letters from the 3 prior complainants. The city, facing a parallel civil lawsuit, quietly commenced settlement discussions. On the day of sentencing, the same courtroom felt heavier. Harlan's family, his estranged wife, and 2 adult sons sat behind him, their faces drawn. Elena took the stand one final time. She looked directly at Harlan as she spoke. That morning, you did not see a citizen. You saw a threat because of my skin color. You used your authority to terrorize me, to remind me that no matter my accomplishments, to some I will never belong. But today, this court reminds all of us that no one, no badge, no bias, is above the law. She turned to the judge. I do not seek vengeance. I seek accountability, so that the next person you might have stopped can simply go about their day without fear. Harlan's turn came next. His lawyer urged remorse. He stood, his voice flat. I respected the jury's verdict. I served this community for 14 years. I made a mistake in judgment that day. I am sorry for any distress caused. There was no mention of race, no acceptance of the hate enhancement. The judge's expression remained impassive. As the appointed moment arrived, Senior Judge Patricia Lang, presiding with solemnity, inclined forward. Mr. Harlan, she declared, her voice resonating through the chamber, the presented evidence does not point to an oversight, but rather a conscious and deliberate decision to unlawfully exploit authority, stemming from deeply ingrained prejudice. This tribunal cannot and will not condone such behavior from individuals entrusted with the sacred duty of protection. Your sentence is 96 months, 8 years within the federal penitentiary system, to be followed by 3 years of supervised release. Furthermore, you are perpetually disqualified from holding any future position within law enforcement. The gavel struck, its definitive sound echoing the finality of the judgment. Immediately, deputies apprehended Harlan and secured him with restraints. As he was escorted from the room, his gaze finally met Elena's. For a fleeting instant their eyes locked. There was no sign of contrition, only a palpable current of defiance. Then he was gone. Outside, the assembled throng erupted in a clamor. News headlines blared within minutes. Renowned judge sentences ex-officer to 8 years for abusive conduct, fueled by racial bias. The repercussions unfolded with swiftness. The city reached a civil settlement with Elena, agreeing to a disbursement of $4,200,000. A significant portion of this sum was designated for the establishment of a new civilian oversight committee and the implementation of mandatory anti-bias training programs. The chief of police announced his decision to step down ahead of schedule. A comprehensive review of body camera footage uncovered numerous instances of unwarranted police stops. Several officers opted to resign before formal investigations into their conduct could reach completion. Harlan was transferred to FCI Medium in Coleman, Florida. The initial processing was unremarkable until the intake officer recognized his name. Word traveled with remarkable speed through the prison corridors. Former law enforcement personnel are seldom met with a warm reception among the inmate population. He endeavored to remain inconspicuous, but isolation soon became his unwelcome companion. Eleanor returned to her judicial duties the subsequent Monday. Ascending to the bench, she surveyed the day's docket, a series of routine matters, including traffic violations, sentencing recommendations, and civil disputes. A subtle shift in the atmosphere seemed to occur. The flag displayed behind her appeared to stand a little taller, a silent testament to the day's proceedings. One court ruling, however impactful, does not obliterate centuries of ingrained bias. It cannot entirely erase the pervasive apprehension that millions experience during even the most routine encounters with law enforcement. Nevertheless, it served as crucial proof. Diligent investigation, unwavering resolve, and considerable bravery can indeed compel a system, even one resistant to change, to function as intended. Months later, Eleanor presided over a separate legal matter. A young black man stood accused of resisting apprehension during what appeared to be an unwarranted traffic stop. The officer's body camera footage clearly depicted excessive force. In her written judgment, citing the precedent set by United States v. Harlan, she invalidated the arrest and dismissed all charges. Justice, though often elusive and glacially paced, had undeniably advanced by a significant measure. If you believe that holding those who abuse their authority accountable contributes to a safer society for all, please consider showing your support by liking this narrative, sharing it with someone who might benefit from its message, and subscribing to ensure you don't miss future installments. We look forward to seeing you tomorrow.